Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hello, everyone.
We hope you didn't miss us too much last week, but Dennis and I are back and all over the news affecting local government law and practice. Dennis.
Helen, local authorities have been very active in the courts during the early summer, with some very important decisions capturing the national news headlines. There was the Kent Council decision declaring the Home Office policy to house unaccompanied children in hotels as unlawful. Then in London, a High Court decision cleared the air on the lawfulness of the Mayor's ULEZ zone. So let's look at this one first.
In a judgment handed down by Mr. Justice Swift at the end of July, the High Court dismissed the challenge brought by 4 London boroughs and Surrey County Council to the Mayor of London's decision to expand the ultra-low emissions zone London-wide. Let's take a closer look into this case. The claimants had been given permission on 3 of 5 grounds of challenge. The first ground principally concerned whether the Mayor had power under the Greater London Authority Act 1999 to expand the ULEZ London-wide by varying the existing charging scheme order, or whether the changes went beyond the scope of a variation so that he was required to make a new freestanding charging scheme order. The second ground of challenge related to whether sufficient and sufficiently clear information had been provided to the public in the consultation TfL had carried out on the proposals. And the third ground of challenge concerned the Mayor's decision to approve a grant payment of £110 million to Transport for London to meet the cost of a vehicle scrappage scheme intended to mitigate certain effects of the ULEZ expansion, where eligibility was limited to London residents and businesses. Now, the High Court dismissed all 3 grounds of challenge. On the first ground, it held that the Mayor had power to expand the ULEZ by way of a variation to the existing charging scheme. And on the second ground, it held that the consultation materials provided enough, sufficiently clear information for the public to make informed responses to the proposals. On the third ground, it held that the Mayor's decision to provide £110 million in funding for the scrappage scheme and his reliance upon this as a mitigation were all lawful. The Mayor had sufficiently understood the limitation to Londoners. That limitation was not irrational, and the eligibility criteria were sufficiently explained in the consultation materials and the materials that informed the Mayor's own decision. Now, the significance of this decision is important beyond London. Over 320 local authorities already have similar emission zones, and many more are considering introducing them. The Lancet report, also in last week's bulletin, points to the clear health benefits associated with this initiative, all of which are beyond doubt. Unlike the politics around this issue, which post-Uxbridge have become a focal point of division. Helen.
Now, the rule of law and ethics is never not out of the spotlight these days, and as Dennis reported on before, the Post Office inquiry is revealing some concerning elements. Reported in the Law Gazette, the statutory inquiry into the Post Office scandal has heard that a senior in-house lawyer within the Post Office advised her employer to throw money at keeping problems with the IT system out of the public domain. And further, that a different lawyer within the Post Office suggested trying to persuade a joint expert who found defects that he was wrong in his opinion. The expert in question was one Jason Coyne, who reported back in 2003 that there were defects with the Horizon system and was not given access to the full list of call logs in regard to one particular post mistress accused of taking money and who was the subject of a civil law claim by the Post Office. Now, Fujitsu, who was the supplier responsible for the Horizon system, sent an internal email stating it was disappointed that Jason Coyne was, quote, unable or unwilling to change any of his original opinions, claiming that the IT expert had assumed the moral high ground and that his analysis was at best selective and at worst simply wrong, and his conclusions. According to a statement by the then Fujitsu internal auditor, The lawyer who was then in charge believed the liability question could be removed, and it was then just about, quote, how much to go away and keep your mouth shut. This is phase 4 of the inquiry, and all the transcripts are available to read, as well as videos of the evidence given on a dedicated website. I've read some parts of the transcripts for the end of July. It seems to me that there was a complete reliance on the system being accurate, without other evidence to collaborate forthcoming. Whilst evidence was given that there would have been existing documents to corroborate, they were not made available to the inquiry, at least by the 27th of July, when that evidence was given to it. To the extent that anyone considered a software problem might have existed in one lone particular postmistress's post office, no one stopped to consider it might be an endemic issue, despite the number of post offices where theft was alleged. We will continue to report from the inquiry, as there are huge lessons for all in-house lawyers embedded within it. Dennis.
The High Court has ruled that the Home Office's policy of placing unaccompanied asylum-seeking children in hotels was unlawful when it became systematic and routine. So let's look at the detail behind this important decision. The High Court has ruled that the Home Office's policy of placing unaccompanied asylum-seeking children, known as UAS children, in hotels was unlawful when it became systematic and routine, and that the Home Secretary has the power to require local authorities to accept UAS children via the National Transfer Scheme. And the court also ruled that a decision by Kent County Council to cease taking UAS children was in breach of the Children Act 1989, and that a deal between the Home Office and Kent that capped the number of UAS children the council would take was also unlawful. In a judgment handed down at the end of July, Mr. Justice Chamberlain considered 3 linked claims from Kent County Council, Brighton and Hove City Council, and a children's anti-trafficking charity that challenged the Home Office policy of placing UAS children in hotels, and also challenged its transfer scheme, which is responsible for transferring UAS children between local authorities. The practice of placing UAS children in hotels is highly controversial and has seen hundreds of children going missing, with evidence suggesting they have joined gangs. At the time of the hearing, 154 children remained missing, the court heard. Kent has taken in large numbers of UAS children as a result of its location and has been calling for changes to the transfer scheme for more than 2 years. The challenge to the Home Office's hotel policy first, Mr. Justice Chamberlain ruled that from December 2021, the practice of placing UAS children in hotels became systemic and routine, and from that point on was unlawful, exceeding the proper limits of the Home Secretary's powers. The judge further ruled that the Home Office's power to direct a local authority to comply with the scheme necessarily implies that where the direction is lawfully made, the local authority is under a duty to comply with it. This means that the duty is enforceable by proceedings for judicial review, even without an express enforcement power, he said. Turning to the claims against Kent, Mr. Justice Chamberlain found the council to be in breach of its duties under the Children Act 1989 by failing to accommodate and then look after all UAS children when notified of their arrival by the Home Office. He said, "It is well established that the duty is absolute and non-derogable and applies irrespective of the resources of the local authority." Helen.
Now, the Local Government and Social Care Ombudsman has updated its guidance to planning practitioners, entitled Not in My Backyard. The report aims to help local people understand more about the planning process and the impact they can have on planning decisions. Also, to help explain the Ombudsman's role and powers in providing redress and supporting independent scrutiny and encourage greater transparency in the way councils reach decisions through sharing the lessons from the Ombudsman's complaints. So the report is divided into 3 sections. The first section looks at the legal background for councils and the roles of the public, local councillors and the Ombudsman in the planning process. The second section includes new personal stories from complaints, which highlight some of the common faults found and the significant impact of poor planning decisions. These show issues such as failure to check the validity of an application, errors in advertising applications, not considering objections, not explaining reasons for decisions properly, failure to consider the impact on neighbouring properties, allegations of bias, and failure to take enforcement action. The third and final part of the report shares learning from complaints to help support better service delivery. This includes a checklist of good practice based on the Ombudsman's experiences of good administration from councils. Some facts. In the year ending March 2023, authorities in England received more than 395,000 planning applications. In the same period, the Ombudsman decided 1,906 complaints and inquiries about planning and development. Of these, 438 were investigated in detail, with faults found in 211 cases. Dennis, what's your last item today?
Helen, in June, the Local Government Association conducted a survey to capture data on the LGA Model Councillor Code of Conduct to gauge the impact of the Model Code on councils. Now, monitoring officers and their governance colleagues will find the survey findings of some interest. Here we go. First, the survey examined the impact and utility of the LGA Model Code. All respondents to the survey were aware of the Model Code. 82% of respondents said they had adopted the LGA Model Code of Conduct to at least some extent, with 25% adopting it in full and 40% adopting the Model Code with some additions or minor amendments. And almost all respondents had reviewed their Councillor Code of Conduct since the Model Code was launched in December 2020, with 85% conducting a formal review and 10% an informal review. And of the councils which reviewed their Code of Conduct, 97% used the Model Code to inform their review. Among councils which used the Model Code to inform their review, 73% reported it being very useful, and 25% stated it was fairly useful. And a light touch review of the constitutions of councils that did not respond to the survey indicated that 54% of non-respondent councils had adopted the Model Code in full or in part. In total, across England, 63% of councils have adopted the Model Code either completely or partially, and 37% have not. Now, have you identified any issues with the use of the LGA code? If you have, let us know via the LLG forum page. Helen.
The Information Commissioner's Office has sensibly upheld legal professional privilege for in-house lawyers following a complaint against Haringey Council, which argued that redaction of advice contained in correspondence between a councillor and the monitoring officer did not constitute a proper client-advisor relationship. Reported in the Local Government Lawyer and elsewhere, the advice originally came from Homes for Haringey and was shared with the MO. The ICO stated that the council received the information as an intended future party to litigation, and it retained its status as privileged information under those circumstances. The information was shared in confidence with a limited number of people at the council, for the purpose of the council continuing that litigation. The ICO was also satisfied that even with the transfer of information between the council and Homes for Haringey, the information retained its privileged status, given that only the relevant individuals at the council were privy to it. Applying the public interest test, the ICO found that the balance of public interest lay in withholding the information and protecting the council's ability to obtain free, frank, and high-quality legal advice. The decision notice said that a weakening of the confidence that parties have that legal advice will remain confidential undermines the ability of parties to seek advice and conduct litigation appropriately, and thus erodes the rule of law and the individual's rights it guarantees. Thankfully, we can all breathe a collective sigh of relief. And on that note, you can read more on the items discussed today, and many more besides, by going to Bulletin number 30, available on the LLG website now. Dennis and I are off for another little break, but we'll be back at the start of September with more comprehensive discussion of matters that are important to our sector. So until then, it's goodbye from me.
And also from me too.
Have a good week, everyone.